Good morning. Today we are here to talk about what is new in California privacy and what does this mean for the company. In particular, we are going to be focusing on the new CPRA in California. My name is Carla J. Utter. I go by CJ Utter. I am registered in-house counsel and director of privacy and data protection at Massimo. And I am being joined today by my colleague Lothar Dieterman, who is a partner at Baker McKenzie up in Northern California. So we are happy to speak about this with you today. Just a few announcements to make. First of all, the views shared herein are our own personal views. We're not representing our company, and this does not constitute a legal relationship or legal advice with us. Certainly, you should, talk to your own lawyer or professional about this with your company and your jurisdiction. There's no warranties or representations herein, and we are not going to share anything that's proprietary or confidential in nature. And we are just representing ourselves, not our company.
Thanks, CJ. Good points. I actually speak on behalf of all the 12,000 professionals at Baker McKenzie all around the world. They always agree with me on every single thing I say or think or joke about. As you said, the biggest new thing is the California Privacy Rights Act, which amends the California Consumer Privacy Act, CCPA, and it remains a moving target. We've covered it together at RSA in previous years, and it is a big shift away from California privacy laws. You see the cover page of my California privacy book here, 600 pages, covers hundreds of different privacy laws in California and on a federal level. These all stay in place, but on top of these harm-specific laws that are very specific on children, on privacy, supermarket club cards, revenge porn, paparazzi, all these different little topics. On top of it, we now have also rigid regulation of parental data processing, similar as in the EU. It started in June 2018 when the first initiative of Californians for Privacy resulted in legislative action. They hammered out a compromise bill that was the CCPA. And because that was passed by the legislature could also make changes to it. There were a flurry of bills. At some point, there were 50 different bills in our parliament in Sacramento. And the Californians for Privacy, led by Alistair McTaggart, felt that there was too much watering down. And so they ended up doing a second ballot initiative, which was on the general ballot in November 2020 and was accepted by a relatively wide margins of Californians, 56%. The reason why it didn't pass in San Francisco, for example, was that people felt it didn't go far enough. They wanted even more privacy regulation. Now, that's why we're focusing today very much on this particular law, but we want to remind everyone there are literally hundreds of other laws that are still on the book. They're not preempted by this, and conflicts between the existing and the new laws aren't really addressed yet by the legislature. In parallel, there are numerous initiatives for federal law, but I think most specialists agree that there is no clear winner or front runner because in the federal Congress, the politicians cannot agree on whether the new federal law should be just a baseline and states can continue to pass hundreds of different laws, or whether there should be preemption. Also, a big sticking point is whether private attorneys should be able to bring private lawsuits on it, or whether this should only be enforced by the government, as it is, for example, largely enforced by data protection authorities. And that is the right of private action. That's a big discussion point that has been holding up a compromise on federal privacy law. In the meantime, the other states are firing away with their own laws. Nevada passed one already a while back that is in effect. Virginia just passed one that will take effect January 1, 2023. And New York, state of Washington, and others are working on their own legislation, all with different varieties, different definitions, and so on. So companies are in for a difficult period of adjusting to these laws, and they will benchmark, typically in my practice, the new laws against what they're already doing under the general data protection regulation in Europe and the California Consumer Privacy Act, which are still the most comprehensive in the world. So this California Privacy Rights Act is not a standalone law, so you're not trying to comply with the CPRA, but you're complying with an amended version of the California Consumer Privacy Act, CCPA, which is amended by this law. This law will be fully effective January 1, 2023, 2 years transition time. However, some of the provisions already took effect when the initiative was certified, which was in November 20. The law can be amended by the California legislature with simple majority, but only if it is consistent with and furthers the CPRA. Many hope that this will put an end to the lobbying and the wrangling where something is tweaked a little bit in favor of companies only to find something in favor of private attorneys or private plaintiffs. And because this can only go one directional now, presumably there will be less amendments. There were actually a number of amendments in the legislature in 2020, but the ballot initiative said anything that was changed after January 1, 2020 will be undone. At the same time, we have regulations from the California Attorney General. They were finalized in August 2020. They were already amended in October, and the new rules took effect in March. So there's a lot of different things to look at, and we want to cover them for you now, boiling them down a little bit, high-level messages, and refer you to additional publications that we'd be happy to share with more detail. The first big question, and I'm giving that to you, CJ, who and what data is protected by this law?
So this law is pretty broad. First of all, it relates to any California resident, natural persons. This does not include a corporation or a business. It's defined as the residency in tax regulations, so that's a good definition to use. And it includes patients, tenants, students, parents, children, employees, candidates, contractors, directors, all the above. And until January 2023, there are less protections for business representatives and employees and your candidates, your contractors, your owners, directors, medical staff members, and individuals that would fall within those classifications. So it is quite broad and covers everybody here in California in one form or another.
Very important point, CJ. The employees have a delayed time until January 1, 2023. There was some idea that maybe a special employee privacy law would be passed. Whether that will happen is kind of unclear. And right now, thinking maybe it'll just be whatever is in CCPA as amended by CPRA right now. But one thing to note, when the initiative was certified, the effective date of that was actually December 16, 2020. At that point, new privacy notices had to be given to California employees, and they already have to be in the style of CPRA, which might have been an unintended consequence of how these deferral rules were done. But important to note, employees and business contacts are not completely excluded from this law. There's just a number of provisions don't take effect yet. So what data is protected, CJ?
This, once again, as I mentioned, is super broad as well, and it's basically intended to relate to a specific person. If the information is supposed to relate to a specific person, then you have to assume that it's personal information. The formal definition means basically information that identifies, describes, relates to, or is reasonably capable of being associated with a person, or could be reasonably associated, linked with this particular consumer or household, would be personal information. And it could be a direct link or an indirect link, but all that, as long as you can assume that it's supposed to be to a specific person, then it is personal information.
I think that's the way to go for designing a compliance program. I get a lot of questions from clients. Is a name, address, person identifier, is that person information, biometric information, internet activity? All of those things are listed in the statute because you have to call them out separately in the privacy notice on your website, and you have to update those once a year, and they have to go back to the beginning of the last calendar year, and so it makes sense to list them all in the statute. But the rule of thumb that CJ just gave is really the way to look at it. If you think that something refers to an individual person, you have to assume it's personal information. And internet IP address as such will have to be presumed to be personal information. There may be some that relate to a printer that is used by many different people in a company that ultimately turns out may not be personal information if nobody can tell who's using it at a given time. But more likely than not, especially here when we speak to the RSA audience with security professionals, you can often find out with the help of other companies or other people who at a given time was using a device, and therefore probably even that would typically be personal information. Now, who has to comply with this law? Where the definition of consumer is only California residents, the definition of a business is any company worldwide. It has to be a for-profit company, and it has to exceed certain thresholds that are intended to carve out smaller companies. Annual gross revenue of $25 million. It's not clear that that's only California revenue, because the statute doesn't say either way, and we have some statutes that say expressly it's global revenue, and we have some that says expressly it's California revenue. And therefore, in this particular law, I think for a compliance program, it's best to assume once you cross 25 million, you're in, even though if you're litigating this, you might be able to claim that only California revenue counts, and then a court will have to decide it. The Attorney General was not willing to decide it in the regulations because it would have been overriding this statutory void. The second threshold would be, even if you have less revenue, if you have more than 50,000 records, this will actually go up to 100,000 as of January 1, 2023, because people have pointed out that that is a really small number. If you get 137 hits on your website a day, that adds up to 50,000 a year. And so that will be increased a little bit, but also rope in a lot of companies, given the definition of personal information is so broad. And then 50% or more annual revenue from selling California residents' personal information. This definition of selling, we'll come back to in a minute, is very counterintuitive, and some say designed to be misleading to trick people at the ballot initiative, the popular initiative, by giving the impression this is cash for data. That's much broader definition. We'll get to that in a second. But this could rope in very small companies that even have very little data, but they want to make a business out of sharing information for consideration. Last but not least, pointing out that parent companies and subsidiaries sharing the same branding are the same business. They may be roped into the law, which is possibly perceived to be a bad thing if you have a parent company out in Japan or in Germany or some other place that is not otherwise paying attention to California laws. But it could be a good thing in the sense that I believe those companies can share with each other without the restrictions of this law, because they are the business and not a third party, and only selling to third parties qualifies for the various triggers on how to comply. Now, when we look at what the law requires you to do, we will find a large laundry list of things that companies have to do. But many of the requirements are triggered by whether the company is selling, and then under CPRA also sharing personal information. And these definitions are somewhat confusing, and I think intentionally picked to be misleading, because these were ballot initiatives that were to be decided by voters. They were made to think this is a consumer law and it's about companies evil, getting cash for data, which is only part of it. So selling is defined to be any exchange of personal information for any consideration that is valuable. Every contract, by definition, under U.S. law, involves consideration, exchange of promises. So data sharing information for receiving information is selling. A company that is getting some other benefit from giving information, let's say providing contact information to a reseller so that they market to somebody, would be selling personal information. Even giving personal information to a service provider would be selling personal information unless an exception applies. There are some exceptions. One is that if the service provider agrees that they will not sell it, that they'll only use it to provide a service, and a number of other requirements, then that would not be selling. But otherwise, the default is if you're sharing information, you're selling. That is intended, and that is one of the key focus areas of the statute. Not the only one, but that is a key one. And in the future, there will be added a definition of sharing. Now, sharing sounds super broad, but it's defined extremely narrowly to mean sharing, disclosing for cross-context behavioral advertising. I think that was a reaction to some industry bodies taking the position that somehow sharing personal information, IP address, and so on for ad networks with double-blind hashing and so on wasn't going to be covered by CCPA. I'm not sure that that was even true, and therefore that this addition is necessary. But whatever it is, that is now also in the law. And if you're doing it, then you have to put a link, do not sell my personal information, or after January 1, 2023, do not sell or share my personal information. And if somebody clicks on that link, there has to be an opt-out page, and people can basically say they don't want this to be happening to their data anymore. If they do it, then you as a company still have to offer the same kind of service. You can't punish people, discriminate against them if they're opting out. That means any sharing that is going on in your business that is necessary, let's say with your cloud provider, infrastructure, other things where you don't have any alternatives, you have to make sure that that doesn't qualify as something that people can opt out subject to anti-discrimination prohibitions, because if they're opting out, you still have to provide the same service to them. Also, wherever you're doing this that you think qualifies as selling, you have to make sure that you're getting opt-in consent from children under 16. Kids between 13 and not yet 16, you can get the consent from them. Anybody under 13, you have to get parental consent, which is already required under federal law. But that is a pretty tough requirement, for example, for companies that work on automated autonomous driving, where cameras capture whoever is in the traffic, and there may be some children, and it'll be very difficult to get their consent in writing and with all the requirements that the CCPA imposes on people, which probably has as a consequence that certain technologies can't be developed or used in California anymore and will have to go elsewhere in order to be successful in engaging in those kind of innovation activities. Now, a big question now is for companies, how do you stop this selling so broadly defined? We're living in a sharing economy. America is all about free speech, freedom of information, collaboration, competition, open networks, open society, open data, open source software licensing. CJ, what do you do in a company in order to get everybody on board with a decision to either engage in selling and offering this link and supporting all these opt-out rights, or cutting out any kind of selling or sharing of information? What do you do practically?
Well, I think as a company, you need to sit down with your executives or your board or your management team and discuss with them what the pros and cons are with selling or not selling the personal information. Once your company has made a decision on how they use the data and which avenue they wish to pursue, given the business needs and the business usage, then you need to work with your different business teams or your business units to make sure that there's proper contract provisions in place that make sure that you are reviewing the vendors that are being used for service providers to make sure that you have the proper precautions in place for whether you sell or do not sell the personal information. You need to train the different business units or business teams, however you refer to them in your company, as to the importance of this and why you need to review it, and you need to work with them to make sure that they are following which choice the company has made to pursue. And, just training all around, just awareness and training is a big factor in making sure that people understand that this is an important aspect of the law.
I think this is very important takeaway from our session here today. This threshold, is the company going to engage in selling or not? Put this link on every single page, website, mobile app download page, and so on, and then support all this opting out without discrimination, without being able to charge people, requires a lot of effort within the company. My sense is that it's still easier for most companies. I work for about 200 companies, some really large, some really small, some are international, some are California headquartered. And of my clients, less than 10 decided to put this link on their website, and they worked along the lines of what CJ is saying and trying to eliminate selling. I think that is still the easier way to go. But some companies can't do that because some form of digital advertising, retargeting or something is really considered mission critical, or that is their business, and they will have to work into this different direction. But it absolutely doesn't make sense to turn to all these other compliance requirements before you made that decision and before you have the executive support for that, because it will be painful either way. And if you're changing course halfway through, it will become unmanageable, particularly since we pointed out this is one of hundreds of different privacy laws that every company has to comply with in California, in other countries. And what you develop for Europe will not work exactly one-on-one for this California law. So here's some other things that need to be done. You have to give privacy notices, and the California Consumer Privacy Act is trying to standardize this by telling companies pretty prescriptively what they have to say in their privacy notices. I think that is a laudable objective, because people are confused and you get all these different privacy notices and they're kind of hard to compare to each other. Everybody uses different terminology. And so if California was the government of the world and not one of 50 states in one country of 192 countries, then it would make sense to tell everybody privacy notices have to look comparably and to be the same. Of course, California is just one state, one of the largest economies in the world, but it's just one state, and companies have to still comply with all these other requirements. And unfortunately, Nevada, Virginia, and other states will not follow California one-on-one on this, fortunately or unfortunately, in the sense that there will be variety. So I recommend that companies develop separate supplemental privacy notices for California, where you exactly work through what the California law requires and don't try to update your general privacy notice. That will be confusing for people in other states, because the California terminology, selling, for example, means something different pretty much anywhere else in the world, even under California statutes. If you write into your general privacy notice, we do not sell and will not sell personal information, and then you engage in an M&A transaction or, lo and behold, an insolvency, and you have to transfer data, you would probably be prohibited from doing that. In California, there is an exception for reorganization and bankruptcy in this very lengthy and complex law, but that wouldn't be implied under the law of Virginia or other states, and therefore you'd have to look at the local definitions. And I think the best way to deal with that is to post supplemental privacy notices. Same is true for privacy notice to employees. RSA is very much focused on security, and I think it's important that you preserve an ability for companies to monitor employees, and so you don't want to create privacy expectations that the employees would then use to thwart internal investigations, deployment of monitoring software and other technologies. And so I wouldn't give the same privacy notices to Americans in other states, and you can't even give the same privacy notices to people in other countries. They have to do supplemental privacy notices. Here's a long list of other things. We won't cover all of them, but we want to give you this as a working checklist and jump to the last one: implement reasonable security measures. Now, this is not prescribed by the statute. It doesn't say anywhere in CCPA specifically you must have reasonable security measures. It's possible that the new California Privacy Protection Agency, that is something that is created right now, the initial board members have been named, that they will put some requirements on companies. And there are other California laws that already require reasonable security. And when Kamala Harris was the Attorney General, in her 2016 data breach report, she suggested what reasonable security means, and I think that's what the California Attorney General would also refer to in connection with this law. But there's no positive obligation yet. There is severe liability for companies that have a security breach unless they can prove they had reasonable security. So it's very important to have that and to document that and make sure. And CJ and I were just talking about, I have a number of clients now that engage cybersecurity or data security professionals to audit the company, but they want that to be attorney-client privilege in case something horrible is being uncovered. And so I'm working through with some clients that want to go and prevent creating a roadmap for a private plaintiff or a regulator by doing a gap assessment, which then sits around and if a breach happens would prove basically the company didn't have reasonable security. And so the way we're doing it is I'm directing the forensic investigators or the cybersecurity experts to create a positive description of technical and organization security measures. And this would be a measure that we could show as a defense and say, hey, we had all these good things. Of course, there will be some gaps and vulnerabilities, and I'm asking the professionals to report those to me. I would then provide attorney-client privilege legal advice to the company to say, here's some recommendations that should probably be fixed. And if the company is saying, yeah, let's do it, then we would create a work stream where this is being worked on. That wouldn't be privileged, obviously. That would just be work, and the consultants would advise what to do. If the company says, no way, we don't have money for this, then it's probably better not to have it in writing and maybe have a conversation with the board or with the executive management to impress on them how important that is, and then start reducing things to writing once there's a willingness to address it. Unfortunately, I have some clients that didn't follow this, and then we have a breach, and then the plaintiffs are demanding to see these reports, and a number of courts have now held that the courts won't be privileged just because when the lawyer was somehow involved in that. If this was created as an ordinary means of business, then the company typically has to produce those kinds of reports. CJ, you're a very experienced long-term security professional. How does that process that I'm describing here sound to you in terms from a practical implementation perspective?
It sounds like a reasonable practice. However, I do think the audit reports are a double-edged sword. They could, help the company, but they could also hurt the company. And that, first of all, I do think the gaps do need to be identified. I do believe they need to be in writing for the teams and for the executives or the management teams to understand, because a lot of individuals do not have the IT background or the IT security awareness. So I think they need to be in writing. And then I think it also should come from like an auditing firm or the cybersecurity professionals, so that there's more cybersecurity bite to it. And I also think that once you have that, you can use that report or that gap analysis to go to your executives and your management team to justify spending the money for the upgrades or to remediate any gaps that you find. Now, if the executive team decides not to remediate those gaps, this audit report showing those gaps and the action or inaction that they decided upon would be a bad thing. However, on the flip side, if your executive team or your management team decides, let's fix those gaps, here's the funding, and then even goes and gets a subsequent audit report done, it could really exonerate a company and really show that the company has taken the sensitivity of the data seriously and looked at these gap reports done by an outside party or an outside firm to really shore up their reasonable security measures. And they did what was considered reasonable by the outside auditors. So it could really go either way for the company, but I do think it would help justify the funding for the gap assessment remediation.
I agree. My own impression is it makes the process very bulky, or can make the process bulky, also depending on who's involved by having the legal department involved. I try not to be ever a bottleneck or delay things, and I'm trying to mitigate that risk, but there is an additional cost to the company, and there is an additional delay possibly, and some companies want to skip that. And I think if they don't have a breach, or by the time they have a breach, they have the gaps all remedied and everything is in good order, then it probably would have been a waste of time and a distraction to involve the lawyer so much. But if there is a risk that the board will not approve whatever spending is deemed necessary by the outside firm, or if the outside firm overreaches or uses, let's say, unhelpful wording in order to try to impress the urgency on a company, then this could be a time bomb and could cost the company millions of dollars later in litigation. And we've had, unfortunately, some experiences with that. So I think that's a great takeaway from you. I'll mention a few things on sanction real quick here, but then want to hear some more takeaways from you, CJ. So any violation of this complex law could be sanctioned by $7,500 for an intent violation. Most violations will be intentional in the sense that the company knew what they were doing. They may not have appreciated that's a violation of law, but they acted intentionally. Only a negligent violation would be where the company accidentally, didn't post the link even though they tried and somebody made a technical error. The money goes into the California Consumer Privacy Fund, which will fund further expansion of enforcement effort. It will fund this new agency, and it will also give 3% to nonprofits who are advocating for privacy to make sure there continues to be a drive for more enforcement, more legislation, more data regulation. There's also a very limited right of private action just for security breaches. If a breach happens and the company can't prove that they had reasonable security procedures, which is always hard once you've suffered a breach, then every California resident gets between $100 and $750, depending on how severe the violation or the negligence of the company was. And that will be putting class action lawsuits on steroids, because it solves a number of problems that the lawyers so far had with class actions, such as showing any harm or commonality of the class, showing that everybody's harmed in a similar way. And all that is solved with this. And so we've seen a huge uptick in litigation. I'm happy anybody reaching out to me to share an article where we gave a little update on what the litigation has been. But let's even look at the positive and see what can we prevent to have litigation in the first place. What are some practical takeaways from this, CJ, that you recommend to companies?
Well, let's start with some short-term goals that practitioners and professionals should consider. First of all, you need to look at your company, look at your data usage, and see if you have what is considered reasonable security for the data that your company is handling, especially personal information, personal data. This requires you to know the sensitivity of the personal information that is in your company's possession. Another avenue you should think about is looking at consumer login credentials and making sure that the consumer login credentials and the prompting questions that go with those are secure as well, because that's considered a breach if those are breached or disclosed. You also need to look at your company's policies, procedures, and security controls around the handling of data, the safe data handling, data hygiene, to make sure that you have all your aspects covered as far as the sensitive data and where it's located. Also, you have to get involved in your risk management with your third parties or your vendor risk management, however it's set up with your company. You must exercise due diligence in this regard, in that in the contract terms, you need to flow through the requirements for the security obligations and the privacy obligations as necessary under the law, and to make sure that there's no selling going on if that is the goal that your company has taken. So moving on to short and more intermediate term goals, you need to make sure your data mapping or your data inventory is up to date. This way you know the sensitivity of the data, where it's going, what service providers are involved, and in what form the data is transferred to your service providers. You also need to sit down with your executives or your management team and talk to them about these new changes in the law, what is required, and to really drive the point home what the sanctions are for non-compliance. A lot of times the dollar symbols or the money involved really impresses upon your management team the importance of these actions. You also need to sit down with your information technology teams or your IT security team or however it's structured within your company to talk to them about security controls and protections and to really discuss with them the type of data you have, where it's located, and the sensitivity of it or the classification that you use for your data. Also, to be mentioned, the right of cure was effectively dissolved with CPRA. And Lothar will talk about that in 1 second. And you also just need to examine your privacy notice to make sure it's accurate and up to date. So Lothar, could you discuss the right to cure and what happened with it with CPRA?
I mean, the idea of this right to cure was for the more formal violations. And because this was originally a ballot initiative in 2018, and then in a very rushed legislative process turned into law, it wasn't changed. And so it looked like the right to cure would apply in security breaches. And people were asking, say, like, how do you cure after you already suffered a breach? And so this was basically corrected, which means if you have a security breach, then the damage has happened, then you'll have to deal with the notifications, and at that point, you probably can't cure anymore.
That's a good point. So moving on to some more action items for your intermediate goals, you must provide training for your stakeholders and for your business units on how to respond to consumer requests that come in and what is required under CCPA/CPRA. You also need to think ahead about employees and business to business, and have you briefed your leadership on the changes for these employees and business to business transactions, and have you prepared your processes accordingly? Once again, I commented earlier on the vendor contracts to make sure you are updating your contracts to flow through the service provider security requirements as well as your sell or do not sell requirements. And also just to review other state privacy laws as they are passed or as they come through, such as Virginia, to determine if your company is in scope for that law and the jurisdiction. And here is just a few more intermediate and long-term goals that you should be working towards in your company. You need to work towards data minimization and purpose limitation with your data. In other words, make sure your company is not data hoarding. And that's a huge undertaking that is probably going to take a long time to get into place and to make sure that you are following through with. This could include the beginning of a data retention policy and process, and then just working towards making sure that you're using the data for the purpose that you state that you're using the data for, and that your company does not retain it for longer than you state or is necessary, just to eliminate the data hoarding.
Now, the data hoarding for the privacy advocates is creating valuable assets for the data scientists at a time when we're really shifting from programming computers with directional instructions to machine learning. We need huge amounts of data sets. And I find in practice, companies are suffering a lot of harm right now, where they're hiring separate privacy teams who may not be as in tune with the needs of the company long-term for innovation, and make promises about data minimization or fail to handle what the purposes of their data collection is proactively, and find themselves at real conflicts where they actually have a good amount of data, but then they made some promises that they would delete it after a short period of time. Maybe then the data scientists have the upper hand and don't delete it, so it sits there. Then it comes out in the data security breach, 10 years worth of data that should have been long deleted turns out there. Or it really is deleted and then not available in order to do training of algorithms, make things more safe and secure. So I think companies need to do a lot of planning here with all these conflicting objectives, requirements on them. And we wanted to just give an overview of what is new in California. We have from the RSA conference a focus of what the amount of time that we have for our session can cover. We would love to answer more questions. I put my email address here. We have a number of articles written on the subject that we'd be happy to share. And if there's a particular hard question, I'll make sure to pass it on to CJ so that she can answer the hard ones.